For admission, item number 1.
Yes, what is this?
It's a criminal revision. We are filing this against a criminal complaint case which was filed against us. So my only contention before this honorable court, is that in a civil matter, a criminal case will not lie because it has a very checkered history of facts also. Because all along there was a litigation, civil litigation between the parties. And after the judgment was pronounced, we went to the field and we have cultivated. So during the process, the respondent, they have burned down the thatch house which we have built. So we have filed a complaint before the Deputy Commissioner. So Deputy Commissioner has endorsed our complaint to the police station. And thereafter, a criminal case was initiated against the present respondent. Thereafter, after the FIR was registered before the against the present respondent, another complaint was filed against the present petitioner by the present respondent. The complaint was filed before the Deputy Commissioner, and the Deputy Commissioner has endorsed the matter to the EAC MON. So the EAC MON, the complaint which was filed by the present respondent was endorsed to the EAC MON. Yes, to take up the issues. So thereafter, the AAC has summoned both the parties, and parties were also summoned and examined. And thereafter, the EAC has given a decision in favor of the present petitioner, saying that the earlier order which was passed by the various court, the EDC Judicial MON as well as the present High Court, basing on that, the EAC has just upheld the order passed by this Honorable Court also. So thereafter, what happened? Again, they have filed a criminal case, alleging that I have trespasses, criminal trespass, criminal conspiracy, and forgery. By misinterpreting the court order, I have cultivated the land. All those issues has been raised. And in the meantime also, they have filed a writ petition before this Honorable Court challenging the decision of the AAC, which was subsequently withdrawn by the present respondent. After withdrawal of the writ petition, they have filed a civil appeal before the District Judge MON, challenging the decision of the AAC. So that the appeal, which was filed before the District Judge MON, we have represented by filing a written objection saying that the civil appeal is not maintainable, as there are certain provisions which has to be followed. So after hearing both the parties, that civil appeal was also dismissed by the District Judge. So now the present petitioner is before this Honorable Court saying that there is no criminal allegation, there is no criminal trespasses or by the present petitioners. So in a civil matter, there should not be a criminal.
Show me the complaint.
It's criminal complaint is at page number 91.
Who are you?
I'm for the petitioner, I'm for the accused.
No, who are you? What is your accused respondent in the complaint?
I'm for the respondent number 1, defendant number 1.
Resident
Accused
of
number
the
one.
accused respondent number 1, believe.
Why Tungam Ang?
Now, what has happened to the complaint? It is going on.
It is pending before the magistrate CGM.
You have got to stay.
Yes, my lord. Relevant para is at page 100, 456. The allegations which they have made in the complaint case. Prima facie, no cases has been made out to initiate criminal proceeding against the present petitioner. Para 4. May I read, my lord? Para 4, page 100.
What is the forgery you are alleging?
Lordship, actually, if we have to go by the entire facts of the case, Lordship. Now, Lordship, since 2001 till the year 2008, there were several litigations and counter litigation between the parties.
But what you are asking at paragraph number 4, at page 100, is in respect to non-compliance to orders, some orders.
Yes, Lordship.
Yes,
Yes,
it
Lordship.
can be a case of forgery. It may be a case of execution of an order or a decree which has been passed. How do you do it? You can't go for a criminal proceeding.
Lordship, actually, they misinterpreted the order passed by the ADC Judicial, Lordship.
No, whatever may be, the order has been passed by the ADC Judicial, rightly or wrongly has been passed. You want for compliance, can you go for a criminal proceedings? One proceeding started
Lordship,
by
because-
A in court A, then you go again in court B.
Lordship, because the land that they have ventured, it's not theirs, Lordship.
Hmm?
The land that they have trespassed upon was never their land, Lordship.
Understood, it's a civil dispute, purely a civil dispute.
Lordship, because they ventured into my land, they started
Absolutely.
cultivation, they started constructing farmhouse. So on learning that my land has been trespassed upon, Lordship, I went and then I destroyed the huts, I burned down the huts.
Is the EAC order,
ADC, Lordship.
EAC,
AAC order.
ADC,
AAC. Extra
EAC.
Assistant Commissioner.
Lordship, the
what
EAC
the
order is based on the ADC order, Lordship.
Okay, whatever may be, is that EAC order or the ADC order
Hmm.
is in existence? Is it in existence?
Lordship, yes.
As per that EAC order, is the land belongs to him?
No, Lordship.
Yes.
No, Lordship.
It's okay. The land does not belong to him.
Lordship.
So land belongs to you as per the EAC order.
Yes, Lord.
Then why did you challenge it?
Because Lordship, they have criminally trespassed upon a
I'm saying about the EAC order. Why did you challenge the EAC order?
because the EAC order was in their favor, Lordship.
And is that EAC order in their favor has a relation to their land, they being in possession of that land?
Lordship, now, if we are to understand the facts, Lordship, now the disputed land called Changhong Changling, now this land has been in dispute for the last many years. Now, in the year 2008, as per the traditional practice, customary order was taken. And in the year
You are
2008,
enjoying a stay?
Yes, yes. Madam.
Okay, we do one thing. We admit this thing. Let it go for hearing.
Lordship,
Better off, isn't it?
Lordship,
It's so much of disputes out there. Yeah. Otherwise, I would, yesterday, if it was there, I would have disposed of. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears, Mr. V. Jimomi appears for the state of Nagaland. And Mr. So-and-so appears on behalf of the respondent number 2. First, taking into account taking into account the matter in its entirety, this court is of the opinion that the instant matter requires to be admitted. Accordingly, the revision petition stands admitted. First, this court have also taken note of the records of CR case number 02/2019 has also been called. Under such circumstances, this court directs the matter to be listed for final listed for hearing on 23rd of July 2024. The interim order passed earlier shall continue till the disposal of the revision application.
You know, I apologize. Earlier record has been called, but the proceeding has not been stayed.
So the
But the record has been called.
record is here. No, there is an interim order.
Yes.
So I'm continuing till the disposal.
Yes. Much obliged.
For admission, item number 2.
Yes. You're also for quashing the other two. No,
No,
what is that?
this is different. This
Oh,
is
it's a civil one.
Yes.
Yes.
The Lordship, my senior, the leading counsel is on his leg in court 1. So if 1 week time will be granted.
Matter pertains to what?
I'm assuming the order passed by the
Injunction.
court. Yes. Refusing grant injunction and upholding trial court's
You got a
order.
stay?
Despite- Yes, I have a stay. As far as the,
In regard to the submission, it is provided that in the returnable that the parties shall maintain status quo of the land as on today, so far as the construction of the new building is concerned. However, so far as the construction of the retaining wall is concerned, we may continue with the construction of our better
Yes.
place. So we fix the matter on some other day and we continue this interim order.
Lordship.
Okay. The counsel appearing on behalf of the respondent expresses difficulties today. Also, taking into account the above, list the matter again on urgency, no urgency.
as I'm concerned.
You have urgency, no urgency.
1 week, your Lordship.
List the matter again on 24th of June,
Very well.
2024. First of the interim order passed earlier shall continue till the next date.
from the supplementary cost list for admission item number 9.
Where are the people? Yes, you were yesterday in the car. And where is Mr. Angami? And where is the council from there? Lehok. We dispose it off. I've heard it yesterday. In fact, I was about to pass the order. This is an application under Section 482 of the Code of Criminal Procedure for quashing of the criminal proceedings against the petitioner in charge sheet number 13/2017 pending before the Chief Judicial Magistrate, Kohima, with reference GR number 53/2017, reference C number 406/419/420/466/68 of the IPC. Full stop. This court have duly heard the learned counsel appearing on behalf of the petitioner, who has drawn the attention of this court to the charge sheet submitted on 6/7/2017, wherein the investigating officer have only filed the charge sheet against one Abhishek Bora and not against the petitioner. He further draws the attention to the portion of the charge sheet wherein it has been mentioned that there no prima facie, wherein the investigating officer has opined that there is no prima facie concrete evidence could be established against the petitioner herein from the available documents. He therefore submits that the question of that the instant FIR requires to be quashed insofar as the petitioner is concerned. In addition to that, he submits that there, in spite of the charge sheet saying, in spite of this, in the charge sheet, the investigating officer has opined that there is no prima facie evidence against the petitioner. Then also, the Chief Judicial Magistrate had to issue the warrant of arrest against the petitioner, which ought not to have been done. Therefore, he has also challenged the issuance of the warrant of arrest in the instant proceedings. I've heard Mr. Yesterday's name, huh? He was N. Angamina. Huh? A. I've also heard Mr. A. Angami, the learned counsel PP, appearing on behalf of the state, who submits that a perusal of the charge sheet would show that no prima facie concrete evidence could be found, but that opinion is based on the fact that the petitioner herein have been absconder, and as such, in spite of various efforts, the petitioner could not be located. He therefore referred to the said portion of the said paragraph of the opinion of the charge investigating officer and submitted that the investigation would be revived again if and when details of the suspect, that is the petitioner, is established to ascertain his involvement in the case and supplementary charge sheets shall be submitted. The learned counsel, the learned PP further brought to the attention of this court that pursuant to the filing of the charge sheet, a prayer has been made for the purpose of further investigation, and in pursuance to that, this warrant of arrest have been issued. So that, yes, here he comes now. Your matter.
Sorry.
Yes. Where is that instruction you have got? Pursuant to that, the warrants of arrest have been issued. It therefore submits that the investigation in respect to the said case have not yet been completed. And as such, the case has been pending because of the stay so granted by this court. The learned counsel appearing on behalf of the respondent number 2 further submits that a perusal of the FIR would categorically show the involvement of the petitioner, in as much as the petitioner, along with the said Abhishek Bora, have represented before the respondent number 2 that they to be the chairman and the general manager of a company, namely MS View Image Infratech Private Limited. And the said petitioner, along with the petitioner, along with said Abhishek Bora, had also induced the respondent number 2 to part with an amount of rupees 35 lakhs, and thereupon they have cheated the petitioner. She therefore submitted that the perusal of the FIR would categorically show that there is a case made out. There is a disclosure of a criminal offense against the petitioner, and in view of the fact that the petitioner could not be located, the investigating officer had opined, had not submitted the charge sheet as the investigation is yet to be complete. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record, including the FIR, the charge sheet, as well as the case records which have been called for. From a perusal of the FIR, it appears to this court that there is a criminal offense have been disclosed against the petitioner, as well as the prima facie disclosed against the petitioner, as well as the said against one Sri Abhishek Bora. This court have also perused the charge sheet, wherein the investigation could only be conducted insofar as the said Abhishek Bora was concerned. However, as the petitioner herein could not be located by the investigating officer, in spite of due diligence, it has been also mentioned that a supplementary charge sheet may be required to submit if there is anything comes out during further investigation. First, this court have also perused the order sheet of GR case number 53/2017. And from the perusal thereof, it is seen that the investigating officer, in order to further carry out the investigation, have sought for the warrant of arrest as well as the transit permit. Transit what?
Permit, I think.
Permit? As well as the transit remand. Full stop. Taking into account the above, this court is of the opinion that as there is a disclosure of the prima facie offense against the petitioner as well as the said Abhishek Bora, pursuant to the in the FIR so filed by the respondent number 2, and the charge sheet also categorically mentions that the further investigation would be required. This court finds no reason to interfere with the further investigation so to be carried out in respect to GR case number 53/2017 in connection with case number 13/2017 under section 406, 419, 420, 468 of the IPC. Full stop. Under such circumstances, this court is not inclined to exercise the powers under 482 in the instant proceedings. The interim orders passed earlier stands vacated. Be that as it may, vacated. The records which were called for by this registry be forthwith returned to the before the court of the Chief Judicial Magistrate. Which one?
Kohima, Lordship.
Kohima, by the registry. Before parting with the record, this court, however, finds it relevant to observe that the instant order so passed and the observations so made shall not in any manner prejudice the petitioner in the trial of the offense, trial in the investigation as well as the trial, if any. In addition to that, the petitioner herein would be always at liberty to avail the provisions of section 438 and 439 of the CRPC.
Lordship, if CD may be returned to me. Copy of the CD may be returned to me, Lordship.
No, I'm saying that the records be immediately forthwith. Or this one.
Oh, yes.
Or this I don't require only. This you have it. I don't put the CD here. Just line to one line you added. In his submission, Mr. Angami has also produced the CD which have been duly perused and returned back.
Obliged, Lordship.
For orders, item numbers 3 and 4.
You are appearing
Yes, Lordship.
for whom?
I'm for the petitioner, Lordship.
Is a limitation?
Uh,
203 days.
yes,
Has the service been complete?
yes, Lordship.
Then what has happened? Who is appearing on the other side?
They have already entered appearance in the last occasion.
Then
That was on 16/5/2024.
what has happened? Tell me why you are filing a civil revision against an order passed by the Civil Judge Junior Division? What order is that? Madam,
Yes, Lordship. Lordship,
Cannot-
the leading counsel
you
is,
cannot file the revision. It is an appeal which lies.
Lordship, however,
An appeal is to be filed. The counsel appearing on behalf of the applicant submits that she requires some further opportunity in the matter. Accordingly, lists the matter after how much? 1 week,
2 weeks.
2 weeks. Okay.
Mhm.
There are many judgments, appeal lies against this order. It's a decree. When an order is passed by rejection of a plain, it is a decree. And if it is a decree, an appeal lies. You can't file here. And if it is an appeal, then it will go to the district judge.
Yes, Lordship.
No.
Much obliged.
For orders, item numbers 5 and 6.
Yes, what is this, madam?
Yeah, please, your lordship. I have instruction to appear for respondent number 1.
42 days. Very well. Who is the respondent number 2? Deputy Commissioner. Anybody from the government? Any government council? No government council. Mr. B.G. Mummy was there. You condone this? 42 days. Let's see what happens. Go and fight in the merits. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number 1. Mr. V.G. Mummy appears on behalf of the respondent number 2. First, this is an application under Section 5 of the Limitation Act 1963 for condoning the delay of 42 days in challenging the order dated. What is that order for?
The order dated 15/11/2023.
Where is that order?
So the last annex, page 18.
Eight?
18 of the condonation petition.
It's an order. Learned Counsel, yes, so and so the preliminary issue has been raised before this court whether this appeal is maintainable. I've heard both sides. Is this page 18?
Yes, Lordship.
It should be noted that my learned friend has already educated upon the issue raised by both sides which have been upheld by the present appeal has been filed, praying for de novo trial and for issuance of direction to the Deputy Commissioner for demarcation of on the question of preliminary issues we have with regard to the maintainability of land. It appears the present appeal has been filed under event for which the court has no jurisdiction and such cannot be entertained. Okay. This is for filing the accompanying revision application challenging the order dated 15/11/2023, whereby the appeal was dismissed on the ground that the court of the district judge Mon did not have the jurisdiction to exercise powers under section 31 of the Rules of Administration of Justice and Police 1937. First up, this court had after duly perusing, hearing the learned counsels appearing on behalf of the petitioners as well as the respondents, and also perusing the materials on record, perusing the contents of the instant application, is of the opinion that that sufficient cause had been duly disclosed within the meaning of Section 5 of the Limitation Act. Accordingly, the delay of 42 days is condoned. I stands allowed. List in the second matter, list the matter for admission for motion on when?
Lordship, if this matter be clubbed together with the first
Lordship,
item, Lordship.
Which one?
The first item, because it is to do with the same matter, the same issue.
First item.
The first item, Lordship.
No, that is criminal. This is civil. No, nothing.
Lordship, I may be given some time to file my counter.
When? No, counter. First, it has to come for admission.
Lordship,
Motion. Then you file your counter. Notice has not been issued to you. Okay, we do one thing. We'll fix it next week. Okay. For motion on, give a date on 21st of June. Mr. Jimami, I put your name as the respondent number 2, the Deputy Commissioner.
Lordship, but it may be fixed on the other day, Lordship.
Huh?
Not on 21st of June, Lordship.
You want some other day?
Lordship.
Okay. 24th of June?
Okay, Lord. Saturday.
Okay, sure.
Lordship.
For hearing, item number 7 and 8.
Fixed day.
Lordship, I'm appearing on behalf of the petitioner and Mishra. Your Honor, the main counsel is having a matter and I involved today. Therefore, the matter may be listed on some other day.
When?
According to the
2 weeks, 4 weeks, 6 weeks, 8 weeks.
convenience of the
Convenience is not there because,
Your Honor,
because here I have seen Mr. N. Mishra is absent in all matters.
2 weeks, Your Honor.
2 weeks, he is supposed to come. Let us take a better date after vacations, July 22nd. What do you say?
Yes, Your Honor.
Fresh from the, okay. At the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to petitioner appealed. It's a what is the matter? The appeal or what? Okay. On behalf of the petitioner, the matter stands adjourned to be listed again on 23rd of July 2024. From here, hearing the matters What do you have to say?
In this matter, I'm told that your lordship had expressed certain views in the matter because of the incongruities in this. I would only like to make a very small submission. This is a case where admittedly no advertisement was made, so there's no doubt about it. So in the normal course, if you go by legitimate expectations, to some extent that is covered. And if that is covered, then Article 14 comes into picture. So one way of looking at it is like what your lordship said last time.
Along with 16.
16. So the scope would be limited on terms whatever your lordship has mentioned. The other way of looking at it is, let us have a look at those persons who have been appointed. I'm not deviating from 14 or legitimate expectation. The main point for consideration is, if you examine the Shivananda case of the Constitutional Bench of the Supreme Court, where certain judges of the trial court, district judges, etc., were appointed.
That's 2024
24.
3
I'll give a copy of it.
I have it.
So if you go by that judgment also, they do agree that when you give a particular set of marks for waiver C, etc., which was not there earlier, a minimum thing which was fixed, there is a breach of legitimate expectation. Therefore, there is a breach of Article 14 also. But the only point which the court considered in protecting the judges was the fact that they were otherwise qualified and they have put in proper service for a few years. Some cases, I think it was between 5 to 6 or 7. There are other cases which speak of a little more also. So the only way that legitimate expectation and Article 14 put together can be balanced is through public interest or the policy of the government. I'm not going to policy of the government here. But as far as public interest is concerned, these people who have been appointed, I think it was somewhere pre-COVID, 2018 or 2018, 19, that time. The first assignment which the Nagaland police was involved in was the era of the COVID. And what was the duty performed by the police at that time is public notice, judicial notice also. And we had a quarantine here, I think Ganesh quarantine or so, which had provision for keeping 2,000 people. So the job of the police was to maintain, to bring those affected from various transport facilities, to look after them, to send them to interior places, for which they have received the accolades from the government. Not only that, many of them succumbed to COVID. After having put in all this service, they again continue to work. It is not that they are not meritorious candidates. And if you go by the rules, the competency of those who selected them, that cannot be challenged because they provide how it will be, and that has been mentioned in the counter. So the same way as in the case of the judges, taking into consideration the number of years they have put in and the emergency situation in which they were appointed,
No, what is the emergency?
I'm coming to that.
2018.
I'm just coming to that. There are judgments which say you have to specify what are the emergency conditions. There are judgments. But from what I was going through, there appeared to have been a ban for some time. And a number of people were collecting. But in that ban period also they were appointing. That's a fact. For whatever reason, when all these people have put in so many years of service, 6, 7 years of service, they qualified to be appointed. Applying the same ratio which the Supreme Court has held in the case of judges. Though, when we speak of Article 14, the principle of violation of Article 14 in the judges' case was different. And here it is different. But you cannot discriminate in between in Article 14 itself. Article 14 is a provision of the Constitution which has infinite dimensions, which is expanded by the day. So if for a particular reason, Article 14, the court says has been violated, the same way, if we see that in our case also it has been violated, then the question for consideration would be, on those terms, the Lordship may kindly consider that as far as these people are concerned, they may be permitted to continue. Because now it's a question of public interest. They have served, they are qualified, they are doing their duty, and they know they worked for the last 7 months or 7 years or so. Kindly see, madam, for Article 14, how they have dealt it in the judge's case. Clear admission.
But this is not a case of without advertisement.
Without?
That's a case of
What I'm trying to explain to your Lordship is, when we speak of advertisement, that is a species as far as the violation is concerned. What exactly is the violation is Article 14.
yes.
Article 14. Likewise here, though it is advertisement.
No,
I know.
Article 14, Article 16.
Article
Article 16 also.
16 also. Both. It applies both ways. Now here, if you go to see this, correct. We have these violations similar to that, and the constitutional provisions also. So the only public interest, so what I'm trying to re-emphasize is, if there is a violation of Article 14, maybe with reference to a particular aspect, that violation from case to case may differ. But the fact is the violation is of equality before the law and the equal protection of the laws. Now, once it is covered under Article 14, suppose in the Supreme Court matter, the violation is on a particular aspect. And in this case, the violation is on a different aspect. All the same, in both the cases, there is violation of 14. So we cannot say in that case that violation is better, and in this case, it is less pronounced. We can't make a distinction in between, because once you say there is violation of 14, it means there is violation of equality before the law, and there is violation of equal protection of the laws. This is my humble submission as far as this point is concerned. So and as far as the judges are concerned, that is more important, because they're going to deliver justice. At the same time, the court also held, see, they are also trained, they will also be doing their job, and there's no impediment as far as the working is concerned. I'm just trying to bring a very small alignment with these two cases on the matter of principle. So this is one submission which I have to make. What your Lordship had in mind was, once again, in the process. Suggestion.
In many cases, just for example, that day I saw one matter sitting in the division bench was a case where a person, as regards the medical people who were appointed during that too after advertisement during the COVID period.
Right.
There you have gone for a special recruitment drive now. Although they have been appointed temporarily for that purpose and there shall be no further right involved. Now you have gone for a recruitment drive. Now how and you may have done it, but at that point of time the COVID was nowhere here.
As far as that question is concerned, I just want to go as far as the constitutional bench judgment is concerned, which is of significance and of significant importance for present concern. As far as the suggestion which your Lordship made is concerned, there was a meeting between the various departments day for yesterday. When I came, I was also there. So, that aspect also. See, forward. I want this administration bench also.
Yeah,
And
well, Mr. Advocate General, I tell you, this judgment of the constitutional bench is not going to help you out. The only way out is you may go, they have been temporarily appointed, very well. I to give this suggestion for the purpose that it would be a less of embarrassment for the state. Because if I set aside, it would be a embarrassment. So instead of that, if the state comes up that look here, we are going to go for a year, we will give some percentage of marks for a year on the basis of works, and also this period when they have worked, that period will be taken for the purpose of age relaxation. If something to that effect, it is better for the state, it would be less embarrassment for the state.
that,
But if you
no, I'm only submitting
has to go
that,
on very
that view also is well taken, that we had a discussion day for yesterday, for which there was further time, which they will look into. Maybe next year, your lordship, because it's already heard, nothing is left, only an order has to be passed. And your lordship's views are there. And now we have the additional to decide the matter. Because we have to take into consideration these people also who have worked, they cannot be thrown out on the roads. But some type of protection is there.
Let the state come back and say that, okay, within next 6 months, we are having a particular year, within a year, till then they will be there. Fix the recruitment or something, and then thereupon you go ahead. Jobs will be, they may they leave it to the state for keeping it only till that recruitment date, nothing beyond that.
So, that is a precise question on which we have had discussions yesterday. So yesterday, since I had advantage of time, so I was just looking into this, going through these decisions also, which your lordship may in any event keep in mind. So after the discussions are completed with them, I would only request your lordships, because this is substantially heard. Now, your lordship has to pass the order, subject to the last minute, whatever additional things we could propose from our side for your lordship's kind consideration. I would only request your lordships, since it is always at a final stage, if we could vote to start doing more. I will keep it part heard, my lord, will appear on any date which your lordship wishes. That's all I'm thinking.
Where do you?
Lordship, to be precise, where is when the appointment is void ab initio, where is the question of legitimate expectation, Lordship?
No, Madam, that point which Advocate General has taken, I have already.
Lordship.
That's not the question.
Lordship.
I'm saying, should I keep the matter parted for the time being and fix a date on which they may come up? There are two things which I have given.
Lordship.
Either this court is going to hold it that the AI is wrong under Article 14 and 16 and set aside. But this court has also take a balance to that effect.
Yes,
that those people who have worked all this time and their age is there to that effect, that age should be relaxed for that. And they may give some marks to that effect, but that has to be reasonable, it can't be more than that. Therefore, I ask the state that taking into account, because you also know, I also know, these people have got their jobs. When there is a backdoor job, there is also, these people are also, would be a sufferer. So instead of that, if the state would have come up with some better thing,
Exactly.
then in that circumstances, the state, the embarrassment which the state is otherwise going to have,
Yes.
will be less.
Yes, Lordship.
Because you see, whatever may be, the appointments are absolutely illegal, can't help it.
Can
The only way is to that effect. As just a special recruitment drive for those in the health department, which was done. That similar drive, if you can go for that. It's showing this way today. Because you see, now, why it is better, you have the representation of all those persons also who are going to be affected before this court. if you take a decision out here now, and this court passes on that basis upon hearing everybody, so to that effect, otherwise their appointment is wrong, then there would be, otherwise there will be another part of litigations where they will come up, what will happen to me and what, where will I go? And they can't do anything here because this order has been passed. And once you take up a recruitment, but when everybody is here, so very well that can be done.
We will place on record a very brief affidavit, chiseling the points in consonance with your lordship's views. And maybe that would give more leverage to your lordships as far as the legal question is concerned. And also those who are likely to be affected, that is, who are already in service, some quantum of security is also, they have it, that if they go through a particular process, their interest would also be taken care of. Because technically speaking, that if you go to the rules also, unfortunately, there is no provision for advertisement, though that is not an excuse. Because under the general principle, the purpose of advertisement is to give notice so that constitutional provisions are catered to. But all the same, we'll place on record a brief affidavit. We'll place it on record, and your lordship may also kindly see the constitutional bench judgment only for this purpose, that such persons who have worked in the area for whatever violation, maybe for a different violation, they also have been protected. I'm not saying we can be protected in the same way as that. Your lordship may be in a position to have a more benevolent view, depending upon the facts and circumstances of the case, subject to law.
No,
So I will file a very short affidavit.
Mr. Advocate General, let me tell you, to be a benevolent view on the basis of the Constitution bench judgment, this court have.
I said benevolent as per law. In such matters, the court has got a paternal jurisdiction.
It would portray a very sorry picture.
No, I'm saying this as far as that particular constitutional bench judgment is concerned. They have safely protected them. I'm not saying that apply that and protecting it likewise, but the spirit is there. The spirit is there that those who have worked, somewhere they should also be protected. And perhaps your lordship has expressed.
They should be protected. Their salary should, whichever they have got.
Yeah.
Normally what happens if it's a void of an issue, the salary, the state may take it. The salary cannot be recovered. There might be, these are protections which can be given. But otherwise you can't help it with that because.
We will make our viewpoint, which will be of assistance to this honorable court. Because various departments are involved. I have seen that, I don't have to make any comment on it. I have seen all the papers. So what best could come out of those affidavits will be placed on record for your lordship's use. Kindly keep it on any date convenient to your lordships. And this may be heard for the reason that substantially it has been heard by your lordships, only for that reason.
Lordship on 25th of July.
Very well.
That's the date
Correct.
I'm having that.
I was also thinking.
Lordship, this case will be a landmark judgment, Lordship, for the state of Nagaland. Apparently, all the backdoor cases that has been filed, none has become successful before the honorable court, and the publics are losing faith in judiciary, Lordship. And this has to be a landmark judgment, even for other departments.
By the time, I mean, on a lighter note, your other sub-inspector also will.
Yes, Lordship. Other constable is also there. Exclusive ones. That was. And not only this, but we pray that the Lordship will give some observation regarding.
Now he is going to submit an
yes,
so
Lordship.
See on that.
But we expect to see that.
I've heard it. The matter has been heard. Only the state put something on record by way of an application. Okay. Heard Ms. Z. Zimomi, the learned counsel appearing on behalf of the petitioners in the instant batch of petitions. I have also heard Mr. K.N. Balagopal, the learned Advocate General, as well as Mr. who assisted by Mr. T.B. Jamil, the learned council. First, upon the Advocate General submits that the state, this court has already completed the hearing of the matter. However, the learned Advocate General submits that the state of Nagaland would file a short affidavit indicating a short affidavit to bring on record the stand of the state. In a short affidavit, first, list the matter for further hearing on 25th of July 2024. Matter be shown as part of it.
Lordship. Obliged lordship.
Oh, yes, you, yes, you give it to me, and that is per case, na? Annexure 37. What is this? Annexure B49 to B52. B13 to so and so. Okay, so these are all different posts, na? Yes, thank you.
Constable post lordship.
And the judgments you did give
Yes,
that
Lord.
day, if you can give it, give me a picture.
This
These are the judgments, no? The 5,
Lord-
6 judgments you were
Lordship.
showing this.
8 are there.
And
Lordship,
Mr.
my lordship,
Mr.
may relate to this also. This
Which
is
one?
the state government's office memorandums since 1976 that no appointment shall be made without advertisement. There are lots, but
No, it's okay.
just
This is there, na? Is it on record? No, is it on record?
lordship,
Are these office members?
one is, yes, lordship.
All are in the report. Huh?
76 is on record and the latest
And
is
the 2001,
2001 is not,
2011,
these two are not.
2016.
16 is ban on appointment, but
Are these on record?
these 3 are not on record.
Why didn't you file also a short affidavit? They are
Lordship, I shall do that, I shall do that.
Okay. During the course of the hearing, certain office memorandums were placed by the learned counsel appearing on behalf of the petitioner. So, liberty is given to the petitioner to file an additional affidavit to the counsel to the petitioners to file an additional affidavit in the lead matter, that is WPC number 189 of the 2022,
Lordship,
bringing on record the said office memorandum.
Lordship.
So taken in the matter having been heard in.
Obliged, lordship.